Yes. Oh, it's probably the transcribe that they mean. Which language? Okay. Good afternoon, everyone. This is a public hearing on a proposed rulemaking by the Vermont Public Utility Commission. And the proposed rule concerns energy storage. We have opened a case in our electronic docketing system, and the case number is 21-3883-RULE. And that case was opened pretty far into pretty far before this proceeding, and has been open for the last year or two. The proposed new rule is it starts a 900 or 9.00 here. Just to be aware, we had when we initially noticed the rule through the Secretary of State, we had a comment deadline, and we received comments from a few folks. But today's hearing is for people to give public comments verbally, and we probably can possibly entertain a few questions too on the rule if people have those. So does anyone want to start or have a comment to make at this point? Yes, go ahead. And when you just give your name and affiliation for the record.
Jonathan Dowds, I'm with Renewable Energy Vermont. I just wanted to elaborate on our written comments in which we said that we thought that the thresholds expressed in the rule should be in terms of export capacity rather than nameplate capacity. I'd hope to have an engineer on the call with me today to get into some of the nuances here. I wasn't able to arrange that, so I'll do the best I can. But my understanding is that for a variety of engineering and technical reasons, the amount of battery you have behind the inverter, the DC capacity of that, and to exceed the AC capacity of the inverter. And REV members have expressed that they believe, as the rule is currently written, that may result in batteries that are smaller than intended in terms of their DC capacity as this rule is envisioned. And so the suggestion is that 5 megawatt limit be based on the AC grid export capacity. This is similar to changes that happened in Rule 5.500 recently, where interconnection studies are now required to be based on projects' export capacity, and I think it more closely aligns with the impacts that these projects have. As far as the footprint of a project, to keep it with a 5 megawatt AC inverter size, you'd be looking at a 4.25 to maybe 4.5 megawatt battery size, and so then increasing that back to 5 megawatts of battery capacity likely would not change the footprint at all, because these are all put inside these sort of fixed size storage units, and likely you would just have to hit that other threshold. You would likely just have one of those storage units that was less filled. So we think that changing the definition to be in terms of the AC grid export capacity would not result in a change, or would result in only a very minimal change in the footprint of the project, would be consistent with what is happening in Rule 5.500, and would not open Vermonters up to any additional impact on the various Section 248 criteria that are excluded under this expedited permitting.
I have actually a question on that. How does that definition, how is that done in ISO New England? How do they when they use 5 megawatts, what do they use for interconnection purposes and their studies and so forth? Do you know that?
I don't know that. I wonder if maybe any of the utility reps that are on the line could speak to it. Otherwise, I can certainly look it up and follow up with you.
Yeah, I don't know if anybody else knows how it's measured at the ISO level. I mean, the 5 megawatt being sort of a cutoff for ISO jurisdiction versus our jurisdiction, and I'm just trying to understand how that would be, if it's consistent or not consistent with that. I don't know if anybody has thoughts. Obviously, we could investigate that ourselves at our end.
My understanding, and again, I can try and follow up with more detail here, is that the projects that the DUs are currently investing in are these sort of 4.99 megawatt projects, and that sizing is based on export capacity, but again, that's something that should have independent confirmation before anyone acts on that.
Yeah. Okay. No. I think I understand your comment, and yeah, I just want to make sure we're consistent across different rules, and how we're measuring I mean, essentially, it's nameplate capacity, but you're saying that it's measured differently.
Yeah, I think it's nameplate capacity versus export capacity is the question. And the language that was suggested to me from our storage members was that it be based on AC grid export capacity.
Okay. Brian, go ahead. Yeah, comment. Question?
Yeah, Mary Jo, you asked what folks thought about ISO New England, how their process works. And I think what Jonathan's talking about is the interconnection point. I think that's where that designation comes from. I could be wrong, Jonathan, but I think ISO looks at how the interconnection request goes in and the interconnection point. That's what I remember.
Okay. We can certainly look at that and follow up and see if that's something that makes sense on our part to change.
Yeah, thank you.
Okay. Does anybody else want to make a comment or ask a question? It's okay if you don't.
Good afternoon. Can you hear me?
Yes.
Okay, great. Hi, this is Allison Milbury Stone, Senior Counsel with Velco, and we also submitted comments in writing by the comment deadline. Just wanted to update you that we have been in touch with the Agency of Agriculture and the Agency of Natural Resources preliminarily, and we're still having conversations with them. We haven't had a chance to come up with any agreed upon revisions to the proposed language that we submitted. Don Einhorn, counsel for the Agency of Natural Resources, did indicate that he would be interested in seeing some sort of quantification of the de minimis standard that we proposed in terms of the streamlined process for certain projects proposed at existing utility sites, and having a little bit of de minimis earth disturbance and tree clearing outside of the existing developed footprint. So that's something we're having ongoing conversations with. And I don't know at this stage, I guess, in terms of next steps, if there are agreed upon revisions, are there other opportunities to present those to the commission?
That's a good question. I think we will provide some additional opportunity if if we, and I am familiar with what your comments that you've filed. If there is the ability to reach, to provide a little bit more consensus behind the comment, I think we can do that. I mean, assuming people are working on that, so we could, once we I was going to kind of wait till after this hearing, but review the comments in full and maybe possibly maybe ask for some additional information and then issue that through an order and set a comment deadline where we have questions on things that people have requested for us to adopt.
Okay, thank you.
I think the hope is, it seems like it's a fairly, we have pretty limited, comments today, and trying to keep the rulemaking on a good schedule is sort of optimal. But if a little extra time helps us get a totally consensus on certain changes, that would be beneficial to going into the LCAR review.
That's good. Thank you.
Okay. All right. Do we have any other comments, questions? So, okay. If not, we can end this, but as I was saying, we're going to review the few written comments that we got, and either ask for some additional information on them, and the one where the de minimis discussion, we might need some additional information, or propose language and ask for people to comment on changes to the rule based on the comments, or respond why we don't think that change is needed, but something to that effect. Just if we think that further opportunity for comment helps kind of facilitate a better rule, we will do that, depending on how things go. I need to run it obviously through our own system here to make sure everybody's okay with it before we make changes, obviously. But in general, I appreciate everybody reviewing the rule and filing the comments that they did file. So if not, if nobody has anything else, we can adjourn. Great, thanks. Bye.
Thank you.